Welcome back. I am the Loud Little Ducky. Today we are going to be going over the judge in Owens V Echard rules on some motions that have been filed lately that we have gone over in our past few videos. So let's see what the Honorable Judge Mata has to say. Okay, so this was filed on or determined on 5/21/2024. As we said, by Judge Mata in Owens V Echard or Gingers v. Woodnick. Order entered by court. The court received and considered defendant/respondent amended motion for relief from judgment based on fraud filed April 26, 2024. Petitioner/plaintiff's petitioner response to respondent's amended motion for relief based on fraud filed April 26, 2024, and respondent's reply to petitioner's response to respondent's amended motion for relief based on fraud filed April 30th, 2024. That all is a mouthful. A bunch of words. Respondent initially filed a motion for relief from judgment based on fraud on March 26, 2024, seeking to set aside the order of protection, the OOP, granted to the petitioner, which is Owens, on October 25, 2023 by Commissioner Duty. Commissioner Duty granted this motion mainly due to determination that the petitioner's alleged sonogram of the alleged twins with whom she was pregnant was posted online by respondent, which is Echard. That's what is alleged. This disputed posting, the commissioner found, constituted cyberbullying and qualified as domestic abuse and justified the order of protection. The March 26th motion was filed after respondent came to believe that the sonogram at issue was fabricated by the petitioner. Thereafter, the respondent filed an amended motion after the respondent became aware of an appointment the petitioner had at MomDoc on November 14, 2023 for a procedure that was not related to pregnancy. Respondent seeks 1. To dismiss the OOP in its entirety with prejudice based on fraud, 2. To grant leave to respondent to submit a China doll affidavit, and 3. To award defendant's attorney fees, and 4. To order further relief as court deems just, including appending consequences to the current outstanding sanctions requested by counselor for the petition. Respondent claims that on both October 6, 2023, the date the temporary order of protection was ordered in ex parte hearing, and on October 25th, 2023, the date of the temporary OOP was made permanent. Plaintiff committed fraud by filing her underlining petition for an OOP and subsequently by testifying before Judge Judy under the false pretense that she was pregnant, respectively. Respondent alleges that this fraud at large involves the petitioner creating a fictitious sonogram of an alleged pregnancy. As a smaller part of this larger alleged fraud, the respondent and petitioner agreed that the petition changed both her name and the name of the facility at which she procured this alleged sonogram during her alleged pregnancy. More specifically, the petitioner claims that the sonogram took place at Planned Parenthood in Mission Viejo, California on July 7, 2023, but that she changed the name of the facility to Southwest Imaging Smile and added her name to the record to prevent the respondent from... I swear it's just bad luck that mowing takes place while I'm recording. I apologize. So they're preventing respondent from contacting the medical professionals who allegedly performed the sonogram and harassing them, and by extension her. So, Owens changed it because she didn't want Clayton to find out who performed the sonogram and harass them and her. Okay, like that makes no sense to me. Plaintiff also claims that she procured the sonogram anonymously. Neither Planned Parenthood in Mission Viejo nor Smile have any records for any ultrasound appointment for a plaintiff as noted in the attached exhibits. Subpoenas were issued for the medical records, and both locations deny having serviced the petitioner on July 7, 2023. Now she's gone back to saying she did it on the 2nd, not the 7th. So, like, we don't have the dates right. She lied to the judge once again. Who knows? Respondent asserts that plaintiff committed extensive fraud upon the court in procuring the order of protection as evidenced by the plaintiff's testification that she had a miscarriage in September before she filed for an order of protection, while representing herself as pregnant with defendant's twins in the ex parte filing, which occurred in October. Respondent separately asserts that the plaintiff committed both intrinsic and extrinsic fraud when, one, plaintiff testified that she sent both a member of the media and a defendant photo of the sonogram, but that only the defendant could have posted the copy of the sonogram. Two, plaintiff testified that the sonogram had not yet been published online when she alleged that the defendant published an image of the sonogram. However, she had already published the sonogram online through a publicly accessible Dropbox. And three, plaintiff testified that she sent defendant the ultrasound photo and ultrasound video when no ultrasound records exist. At large, the petitioner disputes that Commissioner Duty granted the OOP because of the sonogram. Rather, the petitioner asserts that the order of protection was granted because of a combination of alleged text messages that were sent by respondent to the petitioner that were threatening and the sonogram. The petitioner asserts that arguendo, even if the sonogram were not an issue, the alleged action of the petitioner sending threatening text message was sufficient on its own to justify the OOP under ARS 132916, using electronic communication to terrify, intimidate, and then we'll move on. So right now, all this is Judge Matta is laying out what has happened over these past few months. This is basically a summary right now of Owens says, Clayton says. So these are the allegations. These are how Owens says no, those allegations aren't true. And this is how we say they are true. So it's basically just a summary of everything that has happened in this case prior to her making her rulings at the end. So this would be a great video to send people if they want a summary of the case. So threaten, intimidate, or harass, and ARS 132904A prohibiting disorderly conduct. Specifically, the petitioner disputes that the respondents claim that petitioner was never pregnant, citing expert testimony from Dr. Medchill, who claimed the petitioner was pregnant with a 99+% certainty based on 5 HCGs showing positive. This dispute is important given that ARS 133601 requires a party seeking an order of protection to have a specific relationship with the other party. In this case, 133601A3 is pertinent because it describes a case in which the victim of the defendant is pregnant by the other party. In short, if the petitioner was never pregnant by respondent, the OOP would be invalid. Now, I don't necessarily agree with that. If that is what somebody is saying, because you can have a relationship that is considered domestic violence. If you've dated or if you've gotten together and done things, that can be considered. So just because, even if she wasn't pregnant, she would still have the right to file that domestic order thing. But let's see what else Matta says. However, the petitioner claims that even if the petitioner was never pregnant by the respondent, 133601A6 allows the relief in a case where the relationship between the victim and the defendant is currently or was previously a romantic or sexual relationship. That's what I just stated. I do think that part is correct. When Gingrich states that, she did have the right to file it. So I don't think it makes it invalid on the filing matters. Listen, I try to take an unbiased look at things, and I call it like it is. If I agree with something Gingrich says, okay. And when I agree with something Woodnick says, or if I disagree with either one of them, I'm going to state it. Just because I believe one side more so than the other doesn't mean I'm going to point out, I am going to still point out valid arguments and points. Parties have stipulated that fellatio was performed by the petitioner on the respondent twice, which would create a relationship that falls under the rubric of 133601A6. The petitioner also notes that respondent's expert testimony narrowly defined pregnancy as requiring a pregnancy diagnosis by ultrasonic visualization of one or more gestational sacs. The petitioner also asserted that while the petitioner did change the sonogram in terms of adding her name and altering the name of the facility, the substance of the sonogram is true. That is according to Owens. Respondent brings up for the first time medical records from 2016 in which John Chung Kail Chan, MD, diagnosed Laura with real ovarian cancer, not something that just may be there. The same is true for Rebecca Yee, MD, records, who said yesterday, 8/30/16, you received ovary removal surgery, oophorectomy of your right ovary, as well as surgical abortion. The respondent makes much of the alterations the petitioner has made to the alleged sonogram, to wit, the additional of her name and changing of the provider. These actions, the respondent claims, rise above misstatements and themselves constitute fraud. The respondent again asserts the primary basis for the order of protection decreed by Commissioner Duty was the sonogram at issue. The way you published this photo is it's unflattering. That's my reason for making my decision. The respondent alleges that there were 3 sonograms that were altered. 1, the one that was the basis of the order of protection. 2, the one that is dated September 5th, 2023, that the petitioner now claims was faked by one of the prior alleged victims and was sent by the petitioner to both the respondent and one Steve Carbone, Reality Steve. This one was identical to a publicly accessible video that was online from years ago. And 3, the one that was sent from the petitioner's email on October 12th, 2023, that was sent to the media with her commentary. So that is the outlining for all of those things. Now, the respondent also asserts that the petitioner and her counsel, so Clayton asserts that Owens and her counsel are acting contrary to court ordered by posting their filings online on X, formerly known as Twitter. The respondent also asserts that the expert testimony referred to by the petitioner is not credible, given the petitioner did not disclose the medical records from 2016 referred to above to her expert, which may have affected his statements about the likelihood of her pregnancy based on HCG pregnancy test. Respondent repeats his request for setting aside the order of protection and attorney's fees. The court received and considered petitioner's emergency motion to strike and request for immediate telephonic scheduling conference filed on April 30th, 2024, respondent's objection to petitioner's emergency motion to strike, and request for immediate scheduling conference filed on May 2nd, 2024, and respondent's reply in support of emergency motion to strike and request for immediate telephonic scheduling conference filed on May 3rd, 2024. So those are more filings with a bunch of long names, all just spun together. The petitioner Owens filed this motion largely on the basis that the respondent's reply in the amended motion for relief raise new matters rather than only responding to matters raised in the response. Specifically, the petitioner notes for the first time, 1. The respondents brought up the 2016 medical records of petitioner for the first time in the reply, thereby raising new issue. Number 2, the respondents alleged that the petitioner concealed information from her medical expert related to 2016 medical records. 3, the respondent alleged that the petitioner fabricated 3 ultrasounds. Additionally, the petitioner filed this motion asking for an immediate telephonic scheduling conference to discuss whether or not the respondent will be permitted to call several untimely disclosed witnesses. So the judge is not saying that they are untimely here. She is just stating, once again, what is put into these filings. And she summarized it. Even though it may not seem like it's summarized, it actually is. Respondent asserts the petitioner's motion to strike did not conform to Rule 29E and that the disclosed material was timely. The medical records were properly disclosed to the petitioner in a timely manner. The new material included petitioner's medical records is not new to the petitioner. As such, the information raised in the reply was neither untimely nor new. Furthermore, the respondent asserts that the reply responds directly to the response. The respondent reiterates his prior position on the sonogram and requests the same relief as before, with the inclusion of denial of the motion to strike. Petitioner disputes and swears in the affidavit, and we know how I feel about Owens affidavits and declarations. 1. Records disclosed by the respondent as part of 7 supplemental disclosure are fake. The petitioner did not create these alleged fake records, and 3, the petitioner never had ovarian cancer and never had an ovary removed. Petitioner also asserts that 1, she was diagnosed with PCOS in June 2022, when she underwent a pelvic CT scan which confirmed the existence of PCOS and presence of both ovaries. 2, she disclosed the PCOS diagnosis to Dr. Medchill along with the medical records confirming the presence of both ovaries. And 3, she did not disclose the existence of prior ovarian cancer diagnosis because that diagnosis never happened. We know. Petitioner argues that these disclosures are untimely and do not allow her to respond to the new information. They're your medical records that you created. You know well about them. You made them. I mean, you didn't have the doctor's appointment, but you made those records. So you should know all about them. Continuing on, the court received and considered petitioner's motion in limine filed April 30th, 2024, respondent's objection to petitioner's motion in limine filed May 7th, 2024, and petitioner's reply to respondent's objection to petitioner's motion in limine filed May 13th, 2024. So she's going to go over these filings. Notice she's put them in like threes. So she's gone over 9 filings thus far that have been filed. She's done a good job summarizing these things. The petitioner, Owens, seeks to exclude the testimony of Gillespie, Maraschini, and Matt. In short, the petitioner is arguing that the disclosure from the respondents indicating that these witnesses would be testifying did not stipulate the substance about which the witnesses would be testifying. The disclosures state this witness is expected to testify about his prior interactions with petitioner, including his personal knowledge about her alleged fabrication of pregnancy back in 2014. The petitioner disputes that the above sentence is insufficient to meet the standard of disclosing the substance of testimony. Furthermore, the petitioner asserts that the respondent did not close any substance about Maraschini or Gillespie. Finally, the petitioner asserts that the testimony of these witnesses is inadmissible because it is evidence of other wrongs, and that none of the exceptions to this rule apply, e.g. motive, opportunity, intent, preparation, plan, knowledge, etc. The respondent Clayton asserts that Rule 404b2 expressly permits the testimony of these three witnesses. The respondent also asserts that disclosure of intent of the respondent to call these witnesses was timely. The disclosure occurred on March 29, 2024, and the deadline was May 10, 2024. The respondent also argues that oral argument is unnecessary. The petitioner asserts in the reply that the respondent has not disclosed a sufficient summary of the substance of the testimony of the three witnesses. Furthermore, the petitioner alleges that the respondent has not provided valid contact information for Maraschini as required by Rule 49I. However, in the same belief, it is clear that the contact information was provided for Maraschini's lawyer and that the lawyer stated that Maraschini would not be testifying. Mr. Maraschini has a restraining order against him until September 11, 2025. Petitioner also disputes that 2,500 pages of text messages between Maraschini and Owens were timely disclosed, but admits that it was disclosed 3 days before the end of discovery. Petitioner wants to exclude expert testimony from one John Berryhill connected to the text messages since the evidence was alleged not timely disclosed. The petitioner asserts that the text messages have not been independently verified, but does not deny their legitimacy. So they are saying they have not said that they don't believe the expert report on Maraschini's laptop. He doesn't say they're not legitimate. He doesn't argue that point at all, because I don't think he can. I think she had to fess up and admit to her lawyer once again that she lied. Or she didn't mean to lie, she just didn't remember doing it. It was so long ago. I don't even use that game anymore. So I didn't remember that scheme because I quit doing that part of the scheme, even though she hasn't. The petitioner, Owens, requested oral argument. Rule 35C states any party may request or the court may order oral arguments on any motion. The court may limit the length of the oral argument. The court also may decide motions without oral argument, even if requested. The plain reading of this rule indicates that the court may deny a request for oral argument broadly, which would include a request with the caption of a motion without limitation. The case law included below affirms this proposition without qualification. It says, under the family law rules of procedure, the court is not required to grant a request for oral argument in the caption of a motion. The rule governing the question is Arizona Family Law Rules of Procedure 35C, the text of which is expressed above in the brief answer. The rule is further supported by the holdings in 3 unpublished cases in the Arizona Court of Appeals. In Marriage of Butler, and then it says it, holding the court may decide motions without oral argument, even if requested, in Hilly v. Hilly, and holding that the court's denial of litigants' request for oral arguments is not an abuse of discretion since the court has the purview to grant or deny a request for oral argument in Scott v. Neal, holding that under Arizona family laws and family law rules of procedure, I don't know why I can't say that word for some reason. Oral arguments is not necessary even when a movement requests it, and when the court denies that requested oral argument, this does not violate the requester's due process rights. While the court recognizes the case law is persuasive at best, there is no clear published case on point. So she's saying that she has the right to deny oral arguments, and she's cited many things to back that up, that she doesn't need to hear oral arguments, and it is not violating Owens' due process rights. if she does deny the oral arguments. It says the court received and considered petitioner's notice of non-availability and the notice of Echard filed on May 13th, 2024. We did not go over that one because it was just simply Gingras saying he wasn't going to be available on certain dates, and nothing substantial was in it. Like, I don't care when he's available and not available. I don't care about his schedule. Orders. So, here we go. It is ordered. The amended motion for relief from judgment based on fraud filed April 26, 2024 is granted in part and denied in part. So it says, the court will join the order of protection with the current trial on the outstanding issues. The parties previously granted the court permission to observe the order against harassment hearing in case number for purposes of ascertaining any award of attorney's fees or sanctionable actions. The court will also review Commissioner Duty's order of protection hearing and will rule on the validity of the order of protection and any award of attorney's fees at trial on June 10th, 2024 to determine if the order of protection should be affirmed or invalidated. So, she is going to look at these two things. She is not going to give a ruling on the order against harassment, attorney's fees, and sanctions, and she's not going to give a ruling on the order of protection hearing and the validity of it until the trial on June 10th, and see if any attorney's fees need to be awarded there. So we won't know anything else from the judge until the trial on June 10th. It is further ordered the emergency motion to strike and request for immediate telephonic scheduling conference filed on April 30th, 2024 is denied. It is further ordered the request for oral argument is denied. It is further ordered the motion in limine filed on April 30th, 2024 is denied. So she is not going to limit the witness statements of Gillespie, Maraschini, and Matt. She's not going to say that they can't come testify. So basically, she's approving that they can come testify. So they will be in court to say their piece. Thank goodness. Let the record reflect the court notes but takes no further action on the notice of non-availability and the notice of errata filed on May 13th, 2024. She doesn't care about the non-availability stuff. Like, I think that stuff is already passed anyways. Like, and she wasn't going to, since she wasn't going to allow oral arguments or things prior to June 10th, those dates didn't even matter. Or for like a scheduling conference and stuff like that. Like, you're available June 10th, 2024. That's all that matters. She doesn't care about any of those other dates that you had talked about. It is further ordered signing this minute entry as a formal order of this court. It is final. Shut your traps on all this nonsense. Don't bring up 26 sanctions. Don't bring up the motion in limine of these witnesses. Don't talk about none of that. You're going to have to come up with something else. I really do think these next couple of weeks are going to be pretty quiet as far as the docket goes. Now, we know Gingras does not like to be quiet on his Twitter, but who knows, maybe in the meantime we'll learn other new things about him because he won't really have much to say on this. But I guess he's dipping his toe in research and investigative work. I don't know how that's going to go. Doesn't look to be going very well. And based on his research and investigating this case, I'm not so sure about his skills to do that. And then it is signed by the Honorable Judge Julie Matta, Judicial Officer of the Superior Court of Arizona and Maricopa County. And then it has of course, all parties representing themselves must keep court updated with address changes and form and da-da-da-da. So that is the rulings of Judge Matta on all of those motions and responses to motions and everything else that we have been going over for weeks. Like, it's crazy that in 7 pages, she was able to summarize 9 motions. Like, that's amazing. So this is a good summary of what all has gone down as far as after the initial, this is how we got here. This just explains the last couple of months, or actually month and a half since Gingras got on. Like, not even prior to that, but so it's pretty amazing. But it kind of gives a good summary of what has happened in this case. I hope you enjoyed this video. I am so sorry that it took till Thursday of this week to get this out. I hadn't been feeling very well this week. So many ums. I will be putting out Greg Gillespie Part 1 in the next day or so. And we are going to end with our quote of the day by John F. Kennedy. It is an unfortunate fact that we can secure peace only by preparing for war. And I think that is exactly what we're doing in this case. That in order for Clayton to get peace, Maraschini and Gillespie and Matt to get peace, that we had to go to war. They had to battle. And it is unfortunate that they have had to fight this battle so hard in order to live and have some peace from Owens, who has made their lives a living nightmare. And the mowing starts up again when I'm ending. Anyways, I am out for today. Please like this video, give it a thumbs up, share it if you want to let people know about this case, and subscribe if you want to be notified when that Greg Gillespie Part 1 video comes out. I will see you later.